Hello everyone, this is Shiv Prem, legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. So in this today's second session, I will be dealing with some cases related to Uniform Civil Code. In the previous session, I had gone through the Uniform Civil Code, its principles and some basics of Uniform Civil Code and further the ideas of the Supreme Court and the case of Goa. That is one of the best example of Uniform Civil Code in India, where it is followed. So I was explaining that all, BJP party government has already taken steps in the issue of triple talaq and Article 370, which raises the concern of Uniform Civil Code. But Supreme Court also says that there were no steps taken in the 63 years regarding Uniform Civil Code. So there is a very famous case of Muhammad Ahman Khan versus Shah Banu Begum, commonly known as the Shah Banu case. In this case, a Muslim woman was driven out of her husband after 43 years of her marriage. When the woman filed a petition asking for maintenance from her husband in 1979, her husband gave her divorce by citing talaq 3 times, that is triple talaq. He made the defense in the court that he has she has no longer has an obligation to pay maintenance to her wife because he had divorced her and had also paid the amount of dowry during the Idadat period. Idadat period, yeah. In 1979, the Court of Judicial Magistrate First Class held the woman liable to get maintenance at the rate of rupees 25 per month by her husband. Yeah, rupees 25 only. That time it was having a great value, but the appeal was made by the woman in the Madhya Pradesh High Court in 1980. The High Court increased the amount of maintenance to rupees 179 179 to 120, 180, 180 approx per month. The Muslim personal law on inheritance is so indifferent towards Muslim women. The major issue was raised by Y.Y. Chandrachud justice, were as follows, like whether there is no provision in Muslim law for providing maintenance to a divorced wife by her husband, or whether the Muslim law is unequal in the case that no fixed amount is to be paid by the husband as maintenance to his wife. Is it enough to pay something? Sorry, I'm sorry. Is it enough to pay something no matter if it is enough or not? The question of whether Section 125 of CRPC applies to Muslim women or not was answered in the judgment. The Section 125 clause 1 clause subclause A of CRPC provides for the maintenance where she is not capable of maintaining herself when she was refused to maintain by her husband having sufficient means. The term wife here is defined under clause B of the explanation attached to Section 125 clause A as a divorced wife who is not remarried to any person. Thus, the two major requirements of Section 125 to provide maintenance are a divorced wife who is not capable of maintaining herself and her husband who is capable of maintaining her. So, no reference is made in this section of religion. It is nowhere mentioned that it does not apply to Muslim women. The only requirement for providing maintenance is the incapability of a divorced woman, no matter what religion it is she belongs, to maintain herself and the capability of her husband to maintain her. The code is secular and applicable to all its citizens irrespective of their religion. So now let us see what are the benefits and difficulties of having a uniform civil code? Let us go through the benefits that it will promote equal status to all the citizens. One single law for all civil cases. It will one single law for all the civil cases. It will promote gender equality. It will accommodate the aspirations of the young population. It will support the national integration. It will bypass the continuous issue of reform of existing personal laws. Now let us see some difficulties, like practical difficulties due to the diversity in India. Perception of uniform civil code as encroachment on religious freedom. Inheritance of a state in personal matters. Sensitive and tough task. Time is not yet suitable for this reform, and it can create insecurities in the minds of minorities. And the freedom of right to religion comes into conflict with the right to equality. So there is another famous case of Sarla Mugdal versus Union of India. In this case, Supreme Court directed the guidelines of Article 44 of Indian Constitution. The question was raised whether a Hindu husband married according to Hindu law and changed his religion according to Islam, that a person can do second marriage. The court held that a marriage performed according to Hindu law shall be dissolved according to Hindu law under certain grounds specified under the Hindu Marriage Act 1955. But the conversion of religion in Islam and marrying itself dissolved the Hindu Marriage Act, and the second marriage after converting religion is against the Islamic law under section 494 clause 5 of the Indian Penal Code. So the Supreme Court reminded the government of India that the obligation to enact uniform civil code came in July 2003. When a Christian priest go to the doors of court and challenge the validity of Constitution on section 118 of the Indian Succession Act, the priest from Kerala, John Walamaton, similarly the name is, filed a writ petition in the Supreme Court in the year of 1997, saying that the section 118 caused discrimination against Christians, and it imposed unreasonable restrictions on the account of donation of property for the religious purpose. The bench, comprising of Justice V.N. Khare, Justice S.B. Sinha, and A.R. Lakshmanan, and said that the section 180 is to be unconstitutional. So the idea behind the implementation of the Uniform Civil Code is very comprehensive and must be understood properly. Law is dynamic and changes with the need of time. Uniform Civil Code is also an idea to deal with the discriminatory personal laws and deal with changing scenario of the society. It is a secular code for personal laws, which is the need for the country like India, in which secularism is the basic structure of the constitution. It is not implemented in India uniformly. Goa Civil Code is the only uniform code that is not uniform in nature. It applies to only the citizens of Goa, and it also secures some exceptions to it, which makes it non-uniform. Codification of the personal law is also not the end of the Uniform Civil Code. This is an issue to be taken seriously. That's all for now. Let's meet you in the next session. Thank you, and please do like and subscribe the channel. Thank you.